Okay, this is Carl Alford, and I'm sitting here with Paul Nally, and we're going to continue this Arrested Development series. And we're talking, as always, about the grand juries, specifically the one here in the state of Georgia, and what we, as people, citizens of the state, must do in order to get some semblance of sanity back into our system of government. It isn't going to happen by petitioning your governor or your legislature. It isn't going to happen by petitioning your city council or your county commission. No. We only have one place left to go. And that's why they're working so hard to prevent us. Mm-hmm. So we were just talking here a minute ago about who the perpetrators are. The ones that have made this possible. They've taken a republic. They let it morph into a democracy. And now they've turned it into a flat-out tyrannical oligarchy.
Oligarchy is probably the most accurate description.
Yeah. Now, what does that bring to mind? It brings to mind the noble, the elites. And we were warned in the Constitution, Article 1, Section 9, Clause 8, and Article 1, Section 10, Clause 1, about these nobly titled individuals and how they must be precluded from having any positions of profit or trust within the government. And yet they do. Who are these nobly titled individuals? They are the esquires. And curiously, they've taken to dropping that particular title of late, haven't they?
Yeah, it's being phased out. Lawyers don't worry about that esquire anymore.
And yet when you go into their office and look at their look at their degrees and everything, there it is. Mm-hmm. They had esquire bestowed upon them by not the colleges, but by who? By the bar, the British Accredited Registry.
There is probably the worst. Actually, if you trace the corruption, mm-hmm, you're going to find it leads inexorably right into lawyers' offices, judges' offices, and right into the state bar. And it's going to be the state bars that grand juries really need to look at and really need to chastise.
Folks, as an exercise for all of you, you may want to look at just who exactly it is that writes your legislation, mm-hmm, at any level. Let me tell you how it works here in Georgia. A legislator, or can be someone outside of the legislature, that hands a resolution that they want passed by the legislature over to their representative. And that representative, well, he really doesn't know how to write legislation, does he? So what he does is he takes it, here in Georgia, to a group called the Legislative Council. That is a group of 12, count them, 12 esquires, sitting at the Gold Dome. And when I asked one of them, he freely admitted, yeah, we draft all legislation. Wow. So you've got esquires writing law in legalese terms that nobody but them understand. And they're being passed because somewhere buried in this legislation is a particular item that the representative may want to get passed. So That's how this works here in Georgia. And this very same legislative council is responsible for training through their organization all of the all of the council for the cities and the counties. We have a monopoly, folks. Something that is supposed to be prevented here in this country. We have a monopoly in the court system. And the monopoly is simply this. If you are not a bar card carrying attorney, you are not welcome in the courts. What are your thoughts?
Generally, that would be true.
We know it's not lawfully true.
No,
They can't prevent you or I
No.
from presenting ourselves.
No matter how mean an estate any citizen might occupy in our society, they are to be treated with the same accord, the same respect as the most skilled attorney that appears.
Do you feel like that's what's happening?
No, of course not. Of course not. When you've got judges that listen to truthful testimony, by the way, where a district attorney just comes flat out in the middle of the court and says, yeah, I was preventing them from getting to the grand jury, that's my job. And she can't even cite one case law, one statute, or one constitutional provision that gives her that authority. She cannot explain how that claimed authority does not impinge upon or abridge the rights of free speech, the right of assembly, the right to peaceably assemble, the right to petition, and the right to be heard by a grand jury. And she isn't charged by the judge immediately with having committed at least 2 felonies under Georgia law, at least 2 felonies under federal law. Now you got to wonder about the judge.
Okay, let's be specific here. What laws are we talking about? Which ones did she violate?
Well, of course, theft. But theft was a included charge in robbery by intimidation. And then there's violation of official oath of office. So actually there's 3 state felonies violated. And the 2 federal felonies deal with the violations of constitutionally protected guarantees under 18 U.S.C. 241 and 242. And by the way, ran across an article, I think it was in Kentucky, about 2 years ago. A sheriff and a county commissioner were sentenced to prison terms under 18 U.S.C. 241 and 242. They got caught, and the feds prosecuted them. Now I gotta ask, if the feds in Kentucky can prosecute, if you go back to the Greylord cases back in the 80s in Cook County, Illinois, what's going on with the United States Attorney's Office and the FBI down here in Georgia? I mean, for heaven's sakes, we're the most corrupt. Georgia's #1 in the nation. Aren't we a proud bunch of hillbillies?
What can you cite to,
We're #1 most corrupt state in the nation.
how do you come up with that?
Research that was published in New York Times, I think, published that research, and there was another big newspaper. But just run a Google search for most corrupt state from about a year and a half ago, and look and see who it was.
I'll tell you what, when we talk
And
to people,
why?
when we talk to people all over the country, they'll raise their eyebrows and say, "Well, I thought it was my state."
No. As a matter of fact, I've got a friend that lives in Colorado, and she went and took some paralegal training. And she lived here in Georgia for years. She was a teacher. When she gets out there, and she mentioned she's from Georgia, her professor makes no bones about it. Your legal system out there in Georgia is a joke around this nation. I mean, what?
It's a joke.
Oh man, I tell you,
I'm not laughing anymore, Paul.
Yeah, well, you gotta laugh or you're gonna cry.
And that's pretty much where we're at.
You realize we have college-educated people in this state. We have a lot of college-educated people. We got a lot of Bulldog fans. And the vast majority of them dumber than dirt about the things that matter. They have been educated to go out and be complicit little servants for a governmental entity that's going to step the hell all over them one day. Not them maybe, but their children or their grandchildren.
Isn't that?
I have to say, in defense of all of the lawyers that come out of the University of Georgia, in their defense, they're not taught the power of a grand jury. They're not taught the common law origin of the grand jury.
What are they taught?
They are taught to be skillful in reading contracts, but not the special contract we refer to as our Constitution. Now, they don't want to get too deep into that. You know, if you can take the Socratic process up to a point when you're reading the Constitution, but if you go too far, all of a sudden a light comes on in a whole bunch of heads, and these future lawyers understand, oh, we ain't the bad dogs we thought we were going to be. The citizens out here sitting in the grand jury assembled, that's the big dog under this contract, under this special contract we call the Constitution.
You know, again, this is their law of the land. It must be noted, folks, that in Paddleford v. Hayes in Savannah, I don't remember the year right now, but the judge was quick to point out that we, the people, are not party to the Constitution. We don't get any rights from it. It is merely a contract between those that we put in power, our elected, and we the people. It is the thing that binds them, restrains them from doing exactly what they're doing right now.
Yeah, and we're letting them do it by not paying attention to our grand juries and not paying attention to our responsibility to know and understand what we can and cannot do in the grand jury.
So we're talking about, what is it, the Carl Vinson Institute out there?
Bless their little pea-picking hearts. You know, they're so proud when they get that diploma. And then they're even prouder when they get that bar number. And they don't realize that they're stepping out into the world dumber than a box of rocks.
And crazier than a box of red wigglers.
Yeah.
Because
they don't know where the power truly lies. They know where they perceive the power to be.
And the power that they perceive right now is not in the law. It's in the process.
It's in the process. It's not in the law. You're exactly right.
My God. Lord help us. I see young lawyers in the courtrooms, and they're just so full of themselves, and they think they know so much, and they don't know enough to protect our rights.
There was a time I heard, what was his name, Neil Bortz, on the radio, talking about defense attorneys were the last bastion to defend the Constitution. Not anymore. Not anymore.
Who defends it now?
Right now,
Yeah.
nobody.
Well,
Nobody defends our Constitution.
Hold on
anymore.
a second now.
It-
I
it's-
do.
Well, there are exceptions. You know, you and I may step out front and take on a situation, which, like we've just done. But you gotta understand, the people look at us and see what happened to us, and they say, no, I ain't gonna do that. But what they don't understand is, when 500 citizens look at us, 1,000 look at us, and that 500 or that 1,000, or it can just be the congregation from one church, put on their boots, and those boots hit the asphalt in front of the courthouse, shouting, free the grand jury, get rid of the corruption. We demand access to the unfettered access to the grand jury. We want our privileged communication with our neighbors when they are in grand jury assembled. Now you're going to see a whole different attitude, not just in the grand jurors, but in the public servants as well. They're going to start thinking, oh, wait a minute, maybe we better get on our servant cloaks here and take off these robes that...
Well, Paul, the lesson that I hope some will come away from this with is simply this. You will not, I repeat, you will not find any joy in traveling right now up to DC en masse to protest anything.
You don't need to go to DC.
That's the point.
You don't need to go that far.
All you need to do is to get the numbers together and go to your local grand jury where they convene.
Just to give you an example, down in DeKalb County, this past week, there was an SCLC protest because a young man died in custody in the jail. Now, I gotta give them folks credit. They will go out when they perceive an injustice.
Who is they?
The SCLC and their supporters.
And who is the SCLC?
The Southern Christian Leadership Conference.
Thank you.
But here's what they should have done. Instead of just hitting the streets somewhere, or hitting the streets around the sheriff's office or around the jail, that's not the place to protest. The place to protest is right there in front of the courthouse steps when the grand jury is in session. Carry your signs. Say, we want to talk to the grand jury foreman right now. We demand to be heard by the grand jury foreman. Or we demand to be heard by the grand jury. And once that grand jury foreman comes out, tell him. Because under his oath, once he has been told, you don't have to meet with him privately, you can tell him publicly what you want. And what we want is a grand jury inquiry into, one, why did that man die? Why did that young man die in custody, in a jail, when there is so much ready access to medical services that should have precluded anything other than a massive, instantaneous heart attack? Now, the grand jury foreman has a duty, once he's told, and it don't matter if it's the grand jury foreman, it can just be one of the grand jurors. But once one of them's told, under the case law precedent of Henry Lester in our state, he has a duty, that grand jury person has a duty to go back to the rest of the grand jury, tell them what he's heard, and they have a duty, the grand jury itself has a legal, self-enforced, non-discretionary duty under their oath to immediately commence an investigation. And how they do it is up to them. They don't have to go to the district attorney and ask, well, what do we do? They can go straight to the judge and say, listen, Get me an FBI, get me a GBI agent down here. Because we want to investigate what's going on in this jail.
Well, here we go.
Get us the coroner in here. We want to hear the coroner's testimony. They tell the district attorney, they tell the Superior Court judge. That is their power, to tell their servants. And that's another thing that grates on lawyers.
Yeah.
Lawyers don't like the idea of being servant to a bunch of crackers.
There we go back to the elitist mentality.
There you go, back to that mentality.
That oligarchy that.
The oligarchy of the black robes.